Yes, Miss Kelly.
Good morning, my lord, lady. This is my appeal. I'd be here on behalf of the children AA, who is 17 in March.
Well, shall we just have a naming scheme? I'll say the usual, as this case involves children. No report is to identify them or their family, and my own internal naming system is for the two children who this application concerns to be A and B.
Simply A and B.
And I think of their 18-year-old sister as being C, and I don't think we have to have names for any of the others because we know what the history is from the the first judgment.
Then A, who I represent, 17 in March, and B, who's 15 years and 3 months. Along the row, my lord, is Miss Jenkins, who represents the respondents, London Borough of Hackney.
Yes.
Mr. Laurie, who represents the mother, Miss Ojutiku, who represents the father.
Yes.
And Mr. Gupta of King's Counsel, and Miss Mellor, who represents the guardian. They are accompanied by the guardian and the children's solicitor. The parents sit at the back of the court with their with an interpreter. I understand there's some difficulty with interpreters, so they're sharing one. No one anticipates that causing any difficulty.
Good.
Miss Jenkins is accompanied by her social work instructing team, and I have behind me Miss Daly and Miss Gilani of my instructing solicitors.
Right. Well, obviously we've read everything.
Thank you.
And particularly your skeleton arguments, and thank you all for getting it together in the short time over the holiday period. It's obviously important that a decision is given today so that everybody knows where they stand for next week's hearing.
Thank you, my lord. Yes. There has been some discussion outside court as to the order of our submissions. It's proposed that following on from me is the guardian submissions, and then Miss Jenkins and the parents, subject to your approval of that sequence.
That sounds very sensible. And you've seen that there's a time estimate for this
Yes.
hearing. It's a fairly compact issue, and so I'm expecting that we'll be able to finish the argument within something like 2 hours, no more than that.
I think we're all very confident that we will comfortably fit within that, my lord.
Right.
If that helps. My lord, can I just check? There's the core bundle that was filed. There was also a supplemental bundle that was sent in yesterday.
Yes, thank you.
Thank you. So you have had that. My lord, in referencing any documents, would my lord prefer the PDF number or the printed page number?
We'll have the PDF numbers, I think. No, sorry, my lord is there. Are they?
We can do both.
Do they observe traditional discontinuity?
Yes.
Yes, but only by two. All right.
Two
So I think the majority of the court is PDF. So my lord
That's
can do
fine.
the maths.
Thank you, my lord.
Okay.
The order that is the subject of this appeal is found at PDF 29, and it is paragraph 10.
Right, this is approved but unsealed, is that it?
Yes, it was approved on Thursday of last week. So we haven't yet received the sealed copy, but it is approved. My lord, that's the order of Mrs Justice Lieven of the 4th of December, and it relates to child A and B and the refusal for their separate representation, as you know. Just to give some current context, my lord, you know that the trial is listed next week. The directions 13 to 16 have gone awry. We haven't had the closed material that was expected last week, nor have the parents filed their statement that was due yesterday, nor have A and B filed either a statement or letter in response, having considered the judgment as was expected. There is a commitment across the bar to come up with a proposed re-timetable that saves the hearing next week. No one wants that to be lost. I make it clear, particularly my understanding that A and B don't want that hearing to be lost.
Yes.
So that we are confident that we will be able to come up with an alternative timetable. It's likely that we will get the closed material, for example, today.
Right. Well, I'm not surprised to hear that you're likely to be able to do that. While you're making that point, can I understand that the basis upon which you pursue the appeal is that if it succeeded, then you would be ready to go on behalf of A and B next week?
And they were very clear when they were considering whether or not they wished to appeal Mrs Justice Lieven's decision, that they didn't want to do anything that would jeopardise the hearing next week.
In particular, I mean, getting down to cases that there is capacity for example, statements to be produced.
Yes.
Meetings online or in person to be held, and so therefore, in a sense, the issue between the parties is neutral from a practical point of view, namely, either way, the case will be ready to go.
Indeed, my lord.
And so, you know, if you were to succeed on in your appeal, there would be no application for adjournments because we need to do all sorts of important work. Nor, I'm presuming, it hardly occurs, but would there be applications that the judge has got to recuse herself because she's heard this so often and has made a decision? It would go ahead next week on the basis that however the children were represented, the judge would look at everything in the normal way.
Yes, my lord.
Right.
And I understand no one demurs from that thinking.
Yeah. Right. So it's a pure point of a decision about the case management order, which the judge would normally be left alone to decide. You have a challenge in
yes.
overturning it. So, what do you say?
Thank you, my lord. Well, my lord has already indicated that you've read all the documents. Thank you. I've filed a full skeleton.
Yes.
You see the sequence that we go through. I start from Mabon, and that's found in the authorities at page 15 and 16, the paragraph 28 and 9 that I pick there in my paragraph 10 at PDF, in the core bundle PDF 21. And we start from there and the evolution of the children's growing right to independence of thought and action, as is referred to in Mabon, and their right to self-determination. And we follow through the cases that are set out there.
Yes.
Over the page, my lord, my lady, at 22, you see I quote from my lord in Re C, and the emphasis there is mine. There are no presumptions and care will be taken not to overvalue any particular feature. And my lord will know that we say that that's exactly what happened in this instance. The overvalue of the concern about influence that has been a thread running through this case. It's been very clear. We were first instructed in respect of C this time last year. So the proceedings were some way on at that stage, but it was clear at every hearing subsequent to our involvement that the judge was of the view that the parents had lied to her and expressed that view, and was of the view that she couldn't rely on what the children were saying because of the influence of the parents. So that was not new. It wasn't any different when we appeared at the hearing on the 4th of December. And that has been overvalued throughout, we say. When we move on then at paragraph 15 to the reference to Re W and everything that is set out there that my lord referred to, in RISI, you see there echoes of Mabon and the following line of authorities and of developing consideration of the comparison, as he said, between the protection and autonomy and the developing autonomy of children. Moving on to paragraph 16, where we have the case of CS. At paragraphs 63 of that, which is at PDF 92 of the bundle of authorities, Williams J sets out what he calls the 7 factors to be considered, the swift and pragmatic assessment. And we say that that was not seen here, and that those 7 factors were not followed, and that the considerations that have been set out have not been adhered to. And it's worth pausing just for a moment to look at those 7 factors and to see the assistance at, sorry, I beg your pardon, it's PDF 93, and to see the assistance that they would have given.
Paragraph.
I beg your pardon, paragraph 64.
Thank you.
Paper, page 91.
Yeah, got it.
Thank you. And we say that consideration of those range of factors was not done in this instance. And we say, had it been done, that the answer would irresistibly have been that the A and B would have been given permission to be separately represented. At paragraph 23, my lord, and this is an oblique criticism raised on behalf of the Guardian in their position. At paragraph 23, I say that C was given permission to be separately represented at the hearing on the 14th of February 2023. That's my typo. Yes. It was clearly 2024. The age that she was that age. That wasn't wrong. At 24, there is reference there to the provision for the children to file a statement if they so wished. That was the specific direction made by the judge during the hearing. That was what was drafted in the order, and it was only after the hearing and in the drafting that that was objected to on behalf of the Guardian, who said the preference would be that it should be a letter instead. It was particularly unfortunate because the child A had been present for that hearing and had heard that he was to be given permission to file a statement, and was then told that the Guardian and the child solicitor had said that they didn't think he should be allowed to file a statement and should do a letter instead. Whilst it may be a small point for lawyers, it became a big point for the child.
I mean, we've got to understand the context. These things are happening, and I don't object to that, but I can sort of tell from body language elsewhere in the court that that's not quite an agreed position or an understood position. So I'm glad to hear about it from anybody, but
yeah. Well,
it's not. The fundamental point is that for whatever reasons, but the important thing is that they're their own reasons, the children want one solicitor rather than another.
Yes, my lord.
Who is going to say things that they want to say in the way that they want them said, provided it's professionally appropriate to say them.
Indeed. My lord puts it much better than I do, and much more succinctly.
We're not going to investigate who said what to who about statements and letters.
No, I appreciate that it wouldn't be the subject of investigation, but it was a feature for the, certainly particularly for child A, who had heard what he heard. My lord, if I just look very briefly, please, at the skeleton argument filed on behalf of the Guardian, So that's at PDF 68, paper 67.
Which bundle are we in? We're in the core.
In the core bundle, my lady. I beg your pardon.
Okay. What am I looking for?
What you should have in front of you is the skeleton argument on behalf of the Guardian.
Got it.
Yep.
Thank you. I've already made reference to the delay in the approval of the order and the dispute about letter or statement. The key facts that are referred to at paragraph 10 about the court's judgment, they are the fundamental difference is the judgment put in writing, the views that the learned judge had expressed about the parents and the family generally throughout the currency of all of the hearings. Their dishonesty and influence had been for the judge key features of the case. They'd been referred to at each hearing prior to the substantive judgment, and they were clearly the basis on which the court was proceeding. And that was the matrix upon which each decision and direction was being made prior to the judgment, and was the matrix for decision making that applied when C was given permission to be separately represented, as I said, in early 2024 when she was 17. At D, it makes particular reference to the children not being able to speak independently of their parents. That was the view of the court expressed before judgment, in the judgment, and subsequent to the judgment. And so they were the circumstances, again, when C was given permission to be separate.
How are you just exactly dealing with the point that's made in response, which is that the fact that the judge gave a judgment on the 1st of May containing findings about the state of affairs within the family distinguishes the position of C from A and B?
Well, this is my point, my lord.
I just want it in a sentence, as it were.
The judgment puts it in writing, everything that the court had expressed at previous hearings. Right. So we all knew the thinking of the judge and the circumstances. Right.
So your point is that the judge granted separate representation to C, although she had by then formed the same view about what was going on in this family, because at that stage they were they were in Afghanistan and,
yes, my lord.
and refusing to come back.
Yes, my lord. Exactly that.
That's an inconsistency of approach.
Yes, my lady. And of course the confidence that's quoted at paragraph 11 there, the paragraph 57 of the judgment. Although I'm confident that C's legal representative tries to ensure that she is speaking freely in circumstances when she is in Kabul and there is no method of independent verification, I cannot be confident on this. The one benefit we have now that A and B are in the UK is that we can be confident that they have been spoken to separately and independently. And it's raised on behalf of the Guardian that firstly, if I scroll down, page 73, so PDF 75, paragraph 41 that's quoted there from a practice direction document. And halfway down it said, it's noted that Miss Daly and Miss Delani consider A and B to be competent, but in reality both lack substantive knowledge, both being the solicitors, lack substantive knowledge of the family and the children more widely, and do not have the knowledge of the closed material. Firstly, Miss Daly and Miss Gilani have been involved in this case since January of last year, representing C. So they have had substantive knowledge of the case and of the family and of the children.
In this situation, there are professional views held by the solicitors in both firms, no doubt in entirely good faith and based upon the knowledge bases that they have acquired.
Yes.
It doesn't really turn, it's not one of these cases which turns on the view of
No.
particular solicitor or the view of an expert. I mean, Re-C, there was, I remember, a psychiatrist who had
there was.
said loud and clear what the situation was.
Indeed.
So this is, again, it's not going to be a question of preferring one professional view over.
No, I appreciate that, my lord. It's just that it was an unfair criticism levelled at solicitors,
right.
And it was unhelpful.
You say they had a perfectly lengthy and evidence-based understanding of what was going on in this family.
Indeed, my lord. Exactly that. Sorry, I beg your pardon, I went slightly out of sequence there. Again, it may not assist, my lord. If it doesn't, I won't go on. But the paragraph 16, paragraph 12, 15, can't read numbers anymore.
Of your skeleton? Of
the Guardian skeleton at 70. PDF 72. It makes reference to the hearing on the 6th of September. Again, it was a difficult hearing for a variety of reasons, my lord. I attended as a courtesy because we were told, that was on the 21st. We attended, but the application that then followed on the 21st of October was only received at court at lunchtime that day. We attended as a courtesy to the court because on the 6th of September, Mrs Justice Lieven had raised particularly the prospect of the children wanting to be separately represented and had asked Miss Daly through me in court if that was the case, would she be available to represent the children if they approached her? And she confirmed through me to Mrs Justice Lieven that she would be available to do that. And that set up an expectation for A and B, who approached Miss Daly after court and asked her if she would be able to represent them. We then heard nothing from them again until the hearing on the 21st of October, and by which time the orders in respect of C had fallen away because she turned 18. And so we attended as a courtesy to the court because we anticipated a scenario in which the children may attend expecting that, having said to a solicitor outside court, can you separately represent us, they may think that that was what happened.
C continues to be represented by you. We
have once again got public funding for C.
Yes, because she's an adult now.
She's an adult now, yeah. And the new application that is made to be heard next week relates to her.
Yes. So she's responded to that application, and you're kindly attending with your instructing solicitors today pro bono, yes, because there's no legal aid for A and B.
No. And that's caused some practical difficulties, you appreciate, my lord. It meant that there was no formal application before Mrs Justice Lieven because we didn't have funding to do so.
And there wasn't the normal statement from solicitor and so on.
No, as one would expect. The more normal course of events is slightly clunky, but in these scenarios what commonly happens is the certificate is transferred to enable the application to be made. If the application is granted, it stays with the solicitor it's been transferred to. If the application is refused, it gets transferred back to the original children's solicitor. So it's clunky, but it's a mechanism that has evolved to enable people to have the funding to make the applications, to, at the very least, say that costs can be met for issuing fees and so forth. We haven't had the opportunity to do that today, for example, and the costs of issuing this appeal weren't met by a funding certificate. My solicitors have taken that on themselves. So, my lord, it was there on the 21st of October at that hearing, as I say, as a courtesy to the courts and unfunded. And that's when the decisions were made that then became subject of the Guardian's appeal that subsequently led to the listing on the 4th of December for Mrs Justice Lieven to reconsider.
While you were explaining the mechanisms for representation and payment for representation, once it's been decided or agreed that a legal aid certificate will be transferred, is that an onerous process, or is that just very quickly achieved by communication with the legal aid agent?
I think the time scale for that depends on the commitment of both sides, but it normally within a week, my lord, but it can be expedited.
Right.
If my lord is thinking about next week, for example,
well, I'm just trying to cover the whole terrain to see what potential problems are in either direction.
Indeed, indeed, my lord, and that's certainly something that we gave some thought to, but we think would be okay in the event that this appeal is successful.
Okay.
Sorry, if I may turn my back. My solicitor tells me they could also devolve, use their devolved powers for legal aid.
Of internal powers.
Yes. So in the event that that scenario arises, we don't anticipate any difficulties.
Right.
My lord, you'll see the 4th of December then was the hearing that was born out of the invitation from the Guardian and Children's Solicitor for Mrs Justice Lieven to revisit her decision of the 21st. Again, we attended without any funding at that stage because the certificate hadn't been transferred in respect of A or B, and the certificate in respect of C had lapsed because in the intervening period she turned 18 and there were no orders in respect of her and no live applications in respect of her. And that's the hearing then that leads to the direction that we appeal.
Forgive me, is there funding for the appeal?
No, there's not. My lord, we go on. I think every case that has been referred to by all of the parties, they've all referred to the same cases, save I think for the appeal, the skeleton argument in respect of the Guardian, where the President's case of A and B is referred to, and it said reported on the 8th of November, and Lieven J not referred to this case. There's no dispute that influence is a relevant feature. We say undue weight was given to it, and it is one of the considerations. But also here, the children in A and B were 10 and 12.
Yes, and also this was a last-ditch attempt to prevent a return order.
Yes.
That the order for a return had already been made.
Yes.
And there were then a series of hearings to agree the terms of the return.
Indeed.
At which point the children rose up, apparently, and wanted to be separately represented in order to launch a challenge to the return order.
Indeed, my lord. So we say very different.
I mean, I'm obviously
not terribly helpful.
Listen to what Mr. Gupta has to say about it, but it didn't seem to me to add anything to the case that we're considering.
No, well, that was essentially my point, my lord. Thank you. My lord, then when we look down at the wider submissions that are made on behalf of the Guardian, it's accepted at C that this is a complex case, which the court acknowledged when giving judgment and in comments at various other stages throughout the hearings. That is not a matter of dispute. And then there's, again, criticism of not having knowledge of the closed material. By now, we were meant to have had closed material. It was due last Thursday. We have not yet had that. But in any event, that is not a factor that should determine the appropriateness or otherwise of A and B having separate representation. The closed material has not been seen by anyone, save for the local authority and the Guardian. At one point, there were, I think, 3 other adult family members who had party status in these proceedings. None of them had access to the closed material either. It has been.
It's not being suggested that this turns on.
No, well,
Material.
I would say it doesn't turn on it, but it keeps being referred to, so that's why I raise it. And then there is the implied criticism at D that the findings have not been appealed and are directly relevant to the sufficient understanding. I'm not sure who it suggested there in the context would be appealing it. The children wouldn't be appealing it. They didn't have separate representation. The findings weren't made against Charles C. She wouldn't have been appealing it. Whether it's the parents to appeal or not is not going to be a factor to consider for the sufficient understanding point. And so, moving on.
One of the things that the judge ordered, was it on the 4th of December, was that the children should be able to see the judgment.
Yes.
But that had actually, at some stage, been published. I mean,
yes.
Published in an anonymised form, and it's in our bundle of authorities. So I'm not quite sure when it was published in an anonymised form.
It was certainly before the 4th of December, but I think it was in the summer sometime, my lord. I can't remember when.
Yes. Well,
we can certainly check that.
Right. So the judgment's been there for the children to look at if anybody's pointed it to them.
Yes.
Sometime.
It was a specific direction from Her Ladyship that the children be gone through the judgment.
Yes.
And
in answer to your question, what is going to happen about that? I presume that the judge is going to be interested to know what A and B, how they respond to the judgment. She's not going to be changing her findings.
No.
But she will want to know what their perspective is on it.
And that exercise hasn't been undertaken yet, either by the Guardian or by anyone else. And the statement that was, or letter that was due yesterday, hasn't yet been filed. But it's going to be an important meeting for A and B to have someone go through that judgment with them, and that will need to be someone with whom they have confidence that they can talk about, discuss, ask questions about, and that does feed into their wish to have their representative of their choice and to be separately represented. And G, those points at G about one meeting with A and B and querying whether C was present, that formed no part of the Guardian's objections at the hearing on the 4th of December. K hasn't been present at any of the meetings between A and B and their solicitors. A and B have been seen separately and together. They have been spoken to separately on separate phone numbers, on separate video calls, and there have been, including the short meeting after court on the 6th of September, there's been 7 meetings with each of them. They have, between then, September, and the end of last week. My lord, I think they were the particular points that I wanted to either make reference to or amplify for the purposes of my submissions. But of course, if there are any matters that I can assist on in any particular way.
No. Thank
May
you
I
very
just turn my back for
Yes,
one
of course
moment?
you
Thank you, my lord.
Thank you, Ms.
Lady.
Kelly.
Thank you.
Yes, Mr. Gupta.
Your Lordship and my lady. I start by asking the court respectfully to bear in mind that the Guardian who stood behind me has given this matter obviously anxious consideration.
Yes.
She's working with A and B. She's seen B recently and gone through the judgments as A's meeting was cancelled because of illness. And she will carry on working with them, whatever the decision of this court, even if it's to say goodbye, you've now got your own separate representation, or whether it is, if the appeal is refused, whether it's in her current capacity.
Yes.
And what she doesn't want is for these individuals concerned, A and B, to think that she's opposed the application in a steadfast adversarial way.
No.
What she didn't do was support the application in the court below. So if you please look at page 72 of the bundle. Paragraph 22, my instructing solicitor who's seated behind me, Miss May, was very clear. I confirmed I consider the issue of competency with these children somewhat complex, and so I'd invite you, this is the court to follow the procedure, make application to the court seeking separate representation, inviting the court to determine the issue.
Well, you can be reassured that whatever the outcome of the appeal, I don't either sense or feel the slightest degree of criticism of Miss Mahi. I mean, I particularly look at the Guardian's report, which has clearly provided in collaboration with her at page 138.
Yes, indeed.
Electronic 140, in which paragraph 26, the most careful thought has been given to this particular issue in a way that was clearly influential on the judge's thinking, and I can't see any possible basis for criticism.
Well, thank you very much for
or for the. I mean, I understand how the children may feel about it, but
yes,
objectively speaking, the Guardian and the children's solicitor have just been doing their jobs.
I'm grateful, and just to highlight another passage, 73 in the bundle, paragraph 26, children's solicitor Miss May does not support the request for separate representation. Not dead against it, opposing the application, doesn't support it because of the criteria that's been set out in the documents that your lordship just identified, and so that's why we come to this appeal, essentially saying, asking the court, is the judgment of the court below wrong? We don't think it is wrong. We say that the judgment of the court below set out in brief format what the learned judge's views were. The agreed notice, of course, at page 32 of the one that's very short note, but we say it's cumulative because of the decision of the 1st of May earlier last year. And the fact that that was unappealed is not a criticism. The word criticism has come up. We're not criticising, we're simply stating a fact, wasn't appealed, and those facts as set out by the learned judge in the May decision obviously provided the context for her decision that's the subject of this appeal. I'd invite the court, when you're looking at the authorities bundle, to look at Read W, that's the decision of the then Lady Justice Black, which I know the court's fully aware of. But if you look at authorities bundle page 65, paragraph 36, about the middle part of the page, the child will obviously need to comprehend enough of what the case is about without being expected to display too sophisticated an understanding. And this word sophistication, of course, comes up elsewhere in the learned judge's decision earlier on in that paragraph. In cases involving more difficulty, the court will have to take down-to-earth approach to determining the issue, avoiding too sophisticated an examination of the position, and recognising it's unlikely to be desirable or even possible to attempt to assemble definitive evidence about the matter at this stage. All will depend on the individual circumstance of the case. It's impossible to provide a route map to the solution. So it's how the learned judge exercises her discretion on the ground in the context.
It's not really a discretion, is it?
Looking at the FPR, it says it's quite definitive. Maybe I can turn to.
Well, it's an assessment or an evaluation, isn't it?
Yes. And I'm grateful to my own friend on behalf of the appellants, and I should of course said at the outset that my name James and this man is seated behind me. I'm grateful to my friend on behalf of the appellant for confirming that it is accepted that influence is a relevant feature.
Of course.
Because, of course, looking as one does at the FPR, which is set out in the appellant's skeleton argument for ease of reference, page 18. If you just look at the words of it, the court will grant an application if it considers that the child has sufficient understanding to conduct the proceedings. And so it looks pretty bald at that stage, but of course grateful to the nuances that have been provided, and that, as one can see from the McFarlane decision, or Justice McFarlane, the President's decision, 3A and B, influence is a factor. And that's something that and I'll invite the court to have a look, please, at page 19 of the bundle, where the appellant's skeleton argument also reproduces subsection 10, or sub-rule 10. It talks about revoking, page 19, revoking the permission. The court may, if it considers it necessary in order to protect the interests of the child concerned, appoint a children's guardian. And that, again, is the perspective of the guardian, of those behind it, just trying to protect A and B's interests, their autonomy, and the concern is, because of what's been said in the judgment in May, and the court's the judgment in the court below, that's the subject of this appeal, that strings will be pulled, that these children, who are still children just about, will effectively be marionettes, and they'll be placed under some kind of influence, continued influence, for their advocates to say something, which is not actually there for
I think the point that's hanging over my head, and I want to grapple with you, Mr. Gupta, is what's the advantage in these children not having their own separate representation? I can think of a lot of interests it doesn't serve.
Yes.
But what interest does it serve?
Well, the interest of a child or an individual, if we can put it this way, an individual who's been regarded as competent, having the representation they want.
No, but what I mean, I'm yet to understand what the point of the judge's order was. But let's suppose the children are Trojan horses for the parents.
Yes, that's probably a better phrase than marionette.
Well, you use the nicer,
I don't know.
nicer image than that, and that effectively the parents who've been exposed already are now hoping that they'll do better through their children than they managed on their own.
Yes.
So what? If the children come along and the judge listens to them, she may hear all evidence from them, but reads what they've got to say, hears Miss Kelly getting paid for once to put their cases, and she says, well, I've listened to all that very carefully and I find that actually it's just the same old family doing what the family does. I mean, where's the harm in that? The benefits, as it currently seems to me, of the children having their own representation is that they won't have the possibility of, as it were, a double complaint, namely that they've got an order that they argued against, and they were made to argue, that they were made to have their case put by a guardian they didn't want. And when one looks at the overall scheme of things, there's really no balance of argument coming up at the hearing next week at the moment, because the local authority and the guardian are both supporting continuation of the orders for, I don't know how long the local authority will go for, but the guardian wants 4 to 6 years.
Yes.
And the judge is not going to be heavily influenced by anything the parents say. So where's the argument on behalf of these children coming from? I mean, it's one thing that the guardian would loyally put forward what she thinks their views are, but she's going to advocate against them. So at the moment, it seems to me to be an exercise in pointlessness, because this is not a case like Re C, where the child needed energetic protection. If they continue under the guardian solicitor, they're still going to be exposed to pressures from their parents if such pressures are being applied. To tell the guardian what the parents want the guardian to hear and put across to the court. If they're allowed to give evidence, they'll be called by you or by your junior. They don't want that.
Junior.
Yeah, they don't want that. They'll be prepared for giving evidence by the guardian solicitor. They don't want that. And what's the point of going through all that? If I could understand what the product was, because they shouldn't be exposed to something X, Y, or Z, you can't see that. But even allowing for the fact that there is a very strong and coercive culture in this family, as the judge has found, I don't see what the point in depriving them of their own representation is.
Well, Your Lordship, if I can just highlight the word that you used earlier on, which is advocates or advocacy, and that's the key factor, isn't it?
Yes, they don't get any advocacy.
The same information will come to the court through...
Not necessarily.
It may or may not. Yeah.
Yes.
Not necessarily, because however diligently the guardian pursues her obligation of objective and her need to represent them, there's bound to be what I think in some circumstances has been called a filter. So speaking entirely for myself, and I would like to know the answer to the same questions my Lord has just asked, which is who is going to put the case unrestrainedly, apart from professional obligations of propriety, who is going to put the case for the children, given that it won't be the local authority and it won't be the guardian because they're arguing against it, or are thought to be. I mean, the children may have a change of mind, for all one knows, but on the assumption that they have something different that they want to say compared to what the guardian and the local authority are saying, who's going to say it?
Well, Your Lordship, with great respect, here we are in the Court of Appeal, and the assessment is, was the learned judge actually wrong in her determination of the issue of...
Well, I think my Lord's question goes directly to that.
We respect it.
Because it's not a feature that appears in the judgment.
No, short though it is, we respectfully submit that the fact that she's highlighted, the learned judge has highlighted, the influence factor militates towards the decision.
I think what we're allowing you is the opportunity to say, we understand that the judge had other rulings to make at the same time, and this has been picked out, and we're looking at it. We're fully aware that this was not a reserved judgment. It was a case management decision taken orally. But so in a sense we're giving you the opportunity to write the judgment that the judge would have written had she had all the time in the world, which
without a respondent's notice.
And the extra thing that I put in, which I think is also weighing on my mind, is the fact that for perfectly good professional reasons, the children's guardian is not just supporting the local authority's application, but she wants to go much further. She's issued an application for a 3-year extension.
Indeed.
Now, it may be a very good thing that these children don't have passports until they're age 21, or that they can't marry without the permission of the court until they're age 21, but it's nevertheless, it's a major interference with their situation. And at the moment, the guardian is leading the charge for perfectly proper reasons, which may be accepted by the judge, against what the children appear to be wanting. That seems to me to be very uncomfortable for the guardian solicitor, and for the court. And I'm also concerned, rising from my Lord's question, that the quality of the information that the court will have, having set up what's to my mind, surprisingly long hearing, even allowing for interpreters to reconsider and consider your application.
Yes.
That if it's going to devote that amount of time, doesn't it want the best possible information? So anyhow, that's quite a lot
Yes.
to throw at you. But
Picking up the last point.
This is your chance to say, well,
Yes.
you've missed this, or
Well,
where was
the
that?
best possible information, as far as the learned judge and court below is concerned, was by getting it via the Guardian. And yes, I entirely accept there is a filter there with a professional approaching it from the protective capacity. I was going to say best interest, but that's something that's in her mind. It's not paramount necessarily in this domain. But the way to get the unfiltered evidence from A and B, the learned judge and the court below felt that it was the best way was getting it via the Guardian. If the court, this court, however, feels that that's wrong and that's not the best way in the circumstances, then the Guardian's, of course, guided.
Well, it's not so much that what we feel about anything. It's simply to look to see whether the judge considered that quadrant of the of the pitch, as it were, and included it in her thinking. And I'm trying to find it, and I don't see it.
No, I'd be looking back to page 32, which is the agreed note of the judgment. It's not there.
It's also approved that note, isn't it? It's not approved.
Yes.
Sorry, it is approved.
Turn my back from it.
The judge has approved it.
Yes, my lord, last week on the 9th.
So she approved the order and the note, and nobody came up with a transcript. All right.
There's a bit of nodding going on behind Mr. Gupta.
I beg your pardon, sir. Yes. The transcript's been requested, but the note is agreed. I've also seen my learned junior's predecessor's note of the hearing, and it really accords with this. I can't insert into this judgment that which doesn't exist, although I've tried.
But I think it
in
all
different
in the
cases
end,
in this court on many occasions to do so.
I mean, quite sensibly to my mind, Miss Kelly didn't take us on a route march through the grounds of appeal, particularly. I mean, these are just aspects of the same
Yes.
thing. But I mean, in a sense, I'm pressing you just to make sure that we're not being unfair to the judge or to you, to find, in a sense, what the point of this is. Because if it was the case that this is such a sensitive topic and these are disturbed children and so forth, that they need protection, for example, sub-rule 10 you took us to a moment ago,
Yes.
they need protection, then one could readily understand why a court might say they shouldn't be in the arena in a direct litigation capacity.
Yes.
But at the moment, I'm not seeing that these are children who need protection. What they need is they need a decision and an end to the litigation.
Well, yes, although we respectfully submit that despite having a grade A legal team for C, who are ready to and willing to take them on board, that they would be placed potentially under even more pressure when it comes to talking to that new legal team, knowing that their views would actually be advocated.
Well, if the judge was going to, in a sense, if that point was going to be made, and I haven't read it made anywhere, then it needed to be at least somewhere up towards the front of the reasoning, didn't it? Because the welfare consequences of being represented are a prominent part of the equation.
Yes, indeed they are. Can I just turn my back from it?
Thank you.
Thank you. I have nothing further to add. I'm grateful.
Anything else?
Nice.
No, thank you, and thank you also to Miss Bartholomew and to Miss Mellor. Yes, now, Miss Jenkins, you're in the lovely position where it doesn't really matter to the local authority, but you're very keen that this hearing is not derailed.
My lord, that's the local authority's primary consideration.
And also having asked, you were neutral below, you assess that the judge's decision is valid and you're right and entitled to support it. We've read your skeleton argument, but if there are, in a sense, answers to the sort of points that we've been considering that you'd like to bring to our attention, we're all ears.
My Lord, I think they're all raised in the skeleton arguments, particularly by the Guardian, and the local authority's main concern is obviously to keep the hearing. It's to keep Mrs Justice Lieven as the trial judge because of her detailed knowledge of this case, and also her fairness to the family. She's always allowed these children to attend the hearing. She's always allowed them, spoken to them directly, and included them in the process, even when they were in Afghanistan. And the local authority take the view that she's gone above and beyond, trying to include in as fair a way as possible these children in the decisions that she makes. This case is about undue influence and about the protection of the children from that. These are very serious issues that the court's grappling with, and of course the court will need to have the best evidence. So I hear which way, all the questions that you've posed this morning, and as long as the hearing isn't jeopardised next week, the local authority doesn't take issue with the children having separate representation, but their primary concern is that this hearing should go ahead. My Lord, can I assist you further, Anody?
No, thank you very much indeed. All right. Yes, Mr. Laurie. Now, parents are I see, are separately represented today.
Yes, they are.
I'd thrown out a thought about that in the Commission order.
Your Lordship did indeed. I understand there have been discussions between the solicitors. I don't know the outcome of those discussions. I've tried to obtain instructions in relation to that. I know that my learned friend for father perhaps has a little bit more than I do.
Well, anyhow, I don't want to. I'm more grateful that you should have got things together to appear, even if both of you are here, because it's been a short time scale. So
indeed.
Thank you for that. Now we have your helpful skeleton argument.
I'm grateful for that. I'm not going to say a lot because you have heard a lot of argument. You have the skeleton arguments of all of us, but it seems to me that where things have gone off the rails slightly in terms of the judgment are that the judge has posed a question to herself in terms of influence rather than the first question being what the test is.
Rather than the first question being
what the test is, which is sufficient understanding.
Right, so she's focused on influence rather than understanding.
Indeed. And had she focused on understanding, sufficient understanding, that would have led her to a number of factors, a number of which are set out in the various case law, including CS. But because she didn't do that in the first place, she went straight to one particular factor, which led to her giving that overriding, and we say, and we support the children in this, overriding balance to that particular factor, and didn't do the sort of balancing exercise that one would expect.
Was she taken to all these authorities?
I wasn't there.
You
Sorry,
weren't there. Somebody else
I don't
was.
know.
She was
Sorry.
taken to re-W.
But this is very familiar territory, is it not?
Well, one would have thought so, indeed. Yeah. So that is from the point of view of the mother, as I put it to the court, is where matters have gone awry in terms of that judgment and led to the decision that the judge made, which we say is wrong. In terms of just a couple of other points, if I may, the decision the judge was making obviously is extremely important for these young people. They are children in legal terms, but they're moving towards adulthood quite swiftly. And the application from the Guardian now is that the forced marriage protection order should last until they're 21, so well into adulthood. And for these children, in my submission, not to be given the opportunity to directly put to the court, unfiltered, their arguments, their case, their views, on an order that is going to go through until they're 21, it is not right, and they ought to have that opportunity. And putting it through the Guardian, as your Lordship has already observed, or one of your Lordships did, I think it was your Ladyship, is to a certain extent a filter. And there's a guardian saying, well, this is the children's wishes and feelings, and then there's a big but. I disagree with that. I'm the professional in this case. I understand the children's welfare needs, and this is what I say. And that shaves off a lot of the power of the children's views. And so that is something also that is of concern.
And you can't really guard against that in the same way as if they have separate representation, it's open to the judge who decides the application to form an assessment then on the basis of everything. And the assessment may be that the children's evidence is to be given considerable weight,
yes,
or no weight at all, or somewhere in between.
Absolutely.
So you can guard it if you adopt the approach that's being suggested by Ms Kelly. You've got an additional opportunity to weigh the evidence.
Yes, and I was exactly what I was going to say.
Oh,
Actually, no, the influence in this particular case really comes down to the weight the judge places on what the children have to say.
Those perhaps of particular importance because the children would be joining the proceedings in a representative capacity when, in some senses, they're 3 or 4 girls down. That the situation is overhung by the judge's findings, which are important and are not going to be changed.
Yes.
But the judge will have to form a view of what to make of the children's perspective. And so, in a sense, your argument about there not being filters has possibly extra weight in circumstances where this is not a sorry to keep going on like this, but level playing field. That the judge has already made important findings.
Yes.
You'll be describing Miss Kelly as a super sub.
I don't think I need to argue against that.
No, but I'm just thinking aloud
Yes.
about the consequences, yes, because the children are going to have to operate in the environment which has already been identified.
Yes. And if the judge makes the order they disagree with, as has already been said, at least they will have had the opportunity and feel that they've been properly heard. And that comes to the balance of harm point, which hasn't been addressed in the judgment, which comes back to the original point I was making about setting out the test and then from there flowing the various factors that ought to be taken into account in a particular case. That was all I wished to add, unless I can be of further assistance.
No, thank you very much. Thank you very much indeed, Mr. Laurie. Yes, Miss Ojetikun.
Thank you, my lord. My lord, my short skeleton argument is in the supplemental bundle.
Have it, thank you.
I'm grateful for the extension granted for it.
Yes.
My lord, on behalf of the father, I echo the submissions made on behalf of the appellant children and, of course, the respondent mother. My lord, I won't, of course, repeat all that's contained in the skeleton argument, but I raise Article 6, and what the father seeks for the appellant children is for them to have justice and fairness, and more importantly, for them to perceive that they have been justly and fairly listened to, and that their voices have been heard. My lord, the submission with regard to undue influence has been well made, and I won't repeat it. But of course, the issue of undue influence isn't negated by the children being represented by the guardian in any event. My lord, are there any other points?
No, that's been helpful. Thank you very much indeed.
Can I say, with regard to the parents being separately represented,
yes,
those who instruct me liaised with the mother's solicitors to see if the public funding could be linked,
and the parents being represented by one advocate. But I don't think there was a response to that.
Okay. Well, I wasn't meaning to be critical at all. It's just sometimes it works and sometimes it doesn't. But
Yes.
it's been helpful to have you both. Thank you.
Thank you, my lord.
Yes. Ms. Kelly, is there any matter in response?
No, my lord, unless there's anything you would particularly like me to assist you and on.
Just liaise with my colleagues. Well, thank you all very much. We know that you need a decision today, and ideally, if we can give a decision and better still give some reasons for it, that would be the most useful. So we'll try and consider it, see where we've come out, and if we have a decision, work out some reasons for you. I'm going to suggest that you return in time for judgment at 12:30.
Thank you.
If we need longer, well then we'll let you know, but it won't be before 12:30.
Thank you.
Thank you very much.
Yes, is it still on?
Can we leave our stuff?
Will you come out and tell us?
If you could come in for 12:30.
We'll come in for 12:30. Yeah. It's all right to leave things here, is it?
Is anything?
Can we leave our things here?
Leave what you need.
Thank you.
it's ready.
Well, there's such a fair and decent tribunal, do you find?
Yeah, absolutely. What do you think about? Yeah, no, we definitely.
I think all parties were just asking.
On that same issue.
It's called a bill.
You go to the same.
No, this is Archway. Some really
No, very smart.
and they're like 80 quid. Really not bad. And they've lasted the longest. Sods law, isn't it? The Tom Fords didn't last long at all. Oh, and they were so cheap. £2 including the items. Yeah, we could get a sponsorship, product kind of streaming.
It's slightly different. Well, actually,
So, yeah, exactly. It's, you know, let's just cut to the chase. Yeah.
no, I'm not.
Oh, okay.
Oh, okay.
I've got my own.
No, come and join us.
I'm in, where am I? Sheffield.
Anything interesting?
It's all about 1996 Hague Convention and basically children who were abducted from care from Austria and then came over. And the Austrian authorities are quite happy that
Sorry.
they're constantly acquiesced to them living here, which under the 96 Convention you can allow. And apparently if your kids go into care in Austria, parents' rights of custody are stripped. So it's an English case. Not much to argue about, really. I'm fine with 30 gay. Really? To be really. But Paul, do you know, Mrs Justice Paul, really straightforward, really.
I know it. Yeah, you're right.
All right.
Long enough to then go and visit some friends.
You missed your chance. No, that's what I thought. I mean, it wasn't triggering a memory for me.
That's right. Yeah, these are diversity.
You know, think about it, I'm completely forced to
Yeah.
So I've got a theory.
Okay. Maybe they will go to matrix, but there's an insight.
There is, well, one of the things is they said,
Yeah. And who's responsible?
We think it's followed through.
that's this week. But yeah, this is.
So we'll Google what is a sport. There's a sort of culture going on.
Yeah.
And that's why we don't see it. That's why we don't see it.
No.
Whatever, it's all dealt with international. CAS.
Rise if able.
This is a short appeal from a case management order made by Mrs Justice Lieven on the 4th of December, by which she refused permission for the appellant children to be separately represented at a hearing beginning in a week's time. We are grateful to the parties for enabling the appeal to be heard at short notice and for their submissions today. We particularly note that the appellants are represented pro bono by counsel Miss Kelly and by solicitors Messrs Goodman Ray. Having considered the matter, we will allow the appeal. The application for separate representation through Goodman Ray will be granted on the accepted condition that there is to be no application for an adjournment of the hearing next week, and nor is it suggested that the hearing should not be conducted by the judge herself. As this is a purely procedural appeal, nothing I say relates to the decisions of substance that will be taken next week, and I'll give my reasons briefly. And the appellants are A boy aged 16 years and 9 months, and B, a girl aged 15 years and 2 months. By my order granting permission to appeal on the 23rd of December, they have permission to bring the appeal without a litigation friend. The youngest of their parents' 6 children. The family originates in Afghanistan and retains ties there, though it is resident in the United Kingdom. The background is fully set out in the judge's judgment of the 1st of May 2024, reported as LA against M and others, 2024 EWHC 1336 FAM. In summary, the eldest child, now 21, was married in Afghanistan when she was 16 or 17. That was before February 2023, when the legal age for marriage in this country rose to 18. There have been 3 sets of proceedings about these children under the Forced Marriage Civil Protection Act 2007. The first set began in 2022 after the 3rd child, then 16, was feared to be at risk of a forced marriage, and it ended in March 2023 after the family engaged in educative work. However, fresh proceedings were taken in September 2023 after the family unexpectedly went to Afghanistan in July 2023. While they were there, as the judge later found in her May 2024 judgment, the 3rd child was married, then being 17 years old. She revealed this on her return, pregnant, to England in February 2024, but then reverted to denying that any ceremony had taken place, in common with the denial of the entire family. The judge found that the children were under extreme undue influence from their parents. The 3rd and present set of proceedings relate to the youngest 3 children, the eldest of them, C, now being 18, and instructing Goodman Ray since she was 17 in February 2024. These proceedings were brought by the local authority in August 2024 for passport orders in respect of the children until each child reaches the age of 18. A and B were represented by their children's guardian appointed by CAFCAS, and at a hearing on the 6th of September, the prospect of separate representation for them was discussed but not decided. On the 21st of October, the guardian issued an application for passport orders and forced marriage protection orders for the 3 children until the age of 21. On the same day, the judge dismissed that application, leaving the age for the orders at 18 and returning the father's passport to him. That led to the guardian appealing in November and to me granting a stay of the return of the father's passport pending an application for reconsideration. On the 4th of December, the judge agreed to reconsider, and she set up a 3-day hearing for the 22nd of January. That hearing will consider, firstly, passport orders in relation to the mother, father and 3 children. Secondly, an extension of the existing forced marriage protection orders in relation to A and B to the age of 21. And thirdly, a fresh order in relation to C until the age of 21. The judge entertained an unwritten application by A and B for separate representation. Although they had by then been seen by Miss Gilani and Miss Daly at Goodman Ray, who found them capable of giving instructions, the children's solicitor, Miss Mahi, was understandably unwilling to transfer the legal aid certificate without an order of the court, reflecting the view held by the guardian and herself that the children remained under severe pressure from the parents. The judge refused A and B's application for reasons given in a short ruling recorded in an approved note of judgment. She acknowledged that they wished to be separately represented. She described the case as difficult and unusual. She noted that there though there is no doubt that the appellants are Gillick competent, understand the issues and are intelligent. However, she said that the case was not about the children's competence, but rather about whether they're capable of giving instructions without the undue influence of their parents, in the light of the parents having lied about the third child's marriage. The judge said that the case involves the most extreme level of undue influence and coercion, making it difficult to place reliance on what the children say to lawyers and the court. She concluded that they should continue to be represented by a guardian and not be separately represented. She stated that she placed great weight on their wishes and feelings and urged them to speak to the guardian and their solicitor so that their true wishes and feelings can be considered. She asked to hear their response to her judgment. Her order provides for them to make statements or write letters as they may choose, and leaves open the possibility of them giving oral evidence. There are fully 7 grounds of appeal, but the nub of the appellant's submission is the judge did not consider all relevant factors, but was diverted by her finding of undue influence. Reference is made to Maybon and Maybon, 2005 EWCA Civ 634, 2005 2 FLR 1011, which heralded a growing recognition of children's autonomy reflected in Article 12 of the United Nations Convention on the Rights of the Child. The application for separate representation failed to be considered under Family Procedure Rules 2010, Rule 16.6, which deals with separate representation of children. Sub-Rule 6 states that the court will grant an application for a child to be separately represented, quote, if it considers that the child has sufficient understanding to conduct the proceedings concerned or proposed without a litigation friend or children's guardian, close quote. The leading case on separate representation under Rule 16.6 or its companion Rule 16.29 is Re W Representation of Child, 2016 EWCA Civ 1051, 2017 2 FLR 199, where Lady Justice Black gave the leading judgment. For present purposes, I refer to my summary in Re C, brackets of child, close brackets, brackets child ability to instruct solicitor, close bracket, practice note, 2023 EWCA 889, 2023 1 WLR 4065, at paragraph 58, quote, drawing matters together, this survey of the rules and cases shows that whether the answer falls to be given by the child solicitor or by the court, the question will be, does this child have the ability to instruct a solicitor in the particular circumstance of the case, having regard to their understanding? The assessment will be based on a broad consideration of all relevant factors and any opinions from solicitors and experts. The guidance in Re W 2017 1 WLR 1027 bears repeating. Quote, understanding can be affected by all sorts of things, including the age of the child, his or her intelligence, his or her emotional and / or psychological and / or psychiatric and / or physical state, language ability, influence, etc. The child will obviously need to comprehend enough of what the case is about, bracket, without being expected to display too sophisticated an understanding, close bracket, and must have the capacity to give his or her own coherent instructions without being more than usually inconsistent, close quote. The assessment will be case specific. It will not be driven by welfare factors or by a theoretical comparison between protection and autonomy, but by a practical assessment of the child's understanding in the particular context of the case. There are no presumptions, and care will be taken not to overvalue any particular feature. The consequence of a sound assessment will be that the child's rights and interests are respected and preserved, close quote. Here, the judge was therefore called upon to make an all-round assessment of the relevant factors. It was a case management order by a judge with very significant experience of the family, and the appellants inevitably face a real challenge in seeking to persuade us that she was wrong or made a serious procedural error leading to injustice. The local authority and children's guardian resist the appeal in a measured way. The guardian did not support the application before the judge, while the local authority had been neutral. Miss Jenkins and Mr. Gupta, King's Counsel, leading Miss Mellor, emphasised the starkness of the judge's findings about the scale of undue influence and her evident awareness of the countervailing factors, and argued that the decision was squarely open to her in this complex and nuanced case. She properly considered how the appellant's voices could fairly be heard. She emphasised the importance of their wishes and feelings and said that she would place great weight on them. She encouraged engagement with the guardian and solicitor and made provision for an updating analysis from the guardian. Despite the skill and realism with which they were made, I do not accept these submissions for the reasons that follow. Making allowance for this being a short case management ruling, it does not, in my view, take into account sufficiently or at all a number of relevant features. One, these issues are of direct importance for the children. The application seeks to deprive them of their passports and to make a forced marriage protection order for the next 4 to 6 years, 3 years into their adulthoods. These are significant interventions in their lives, however necessary they may be found to be. 2. Significantly, the application to which they apparently object is being prosecuted by their guardian. She would no doubt record the children's views, but she would advocate against them. That is likely to foster a feeling of dissatisfaction and even a perception of unfairness. To an observer, it might seem odd that the party making the application was also responsible for putting forward the contrary view. The judge acknowledged that these are intelligent older children, but she did not give weight to the impact on them of her ruling. 3. Nor did the judge consider the advantages to the court of having the best possible information from the court, unfiltered by others. Also, there would be no effective counterparty to the applications made by the guardian and local authority. The judge's assurance that she would place great weight on their wishes and feelings does not provide a remedy in the absence of the opportunity for advocacy. That is of added significance where she has already made important findings about their family. 4. The judge did not explain why it was consistent for these children not to be separately represented when their near-age sibling C was and will be. 5. Again, significantly in my view, the judge did not identify any negative welfare consequences arising from separate representation, as was the case in the decision in Re C. And counsel for the guardian and local authority were not able to suggest any to us. Nor did she address the clearly arguable advantages to the children of feeling that their arguments had been made in the way that they wanted, particularly if the decision is an unwelcome one. 6. Although there are no presumptions, children of this age would normally expect to be separately represented, even in cases of high emotion. Forced marriage cases, by definition, involve allegations of possible or proven coercion. Yet that factor alone cannot be decisive of an older child's ability to give instructions, else it is hard to see when children could ever be separately represented in such proceedings. 7th and finally, arrangements for separate representation would cause no delay or significant expense. My conclusion is therefore that there has not been the necessary all-round assessment of the relevant factors. The judge's decision cannot stand, and we must remake it. In doing so, I would accept without hesitation that the findings about the severity of the parents' undue influence must be a major feature. But in all the circumstances, it does not lead me to the conclusion that the children do not have the ability to instruct a solicitor having regard to their understanding. Their understanding needs to be sufficient, not complete. By allowing them to be involved in the decision in the way that they seek, the court is likely to gain a fuller view of the arguments, and the children may find it easier to accept the outcome, whatever it may be. The court will be alert to the likelihood that their views have been influenced by their parents and older siblings, and it will reach its conclusions about that. But its focus will be on making the best decision to protect the children from risks of forced marriage, and that will not be helped by restricting their participation in the decision-making process in a way that would foreseeably overshadow the upcoming hearing about their welfare and protection. For these reasons, and for those that will, I believe, be offered by Lord Justice Stuart-Smith, with which I agree, I would allow the appeal and grant the application for separate representation. This outcome entails no criticism whatsoever of the guardian or her solicitor, who have been conscientiously carrying out their duties on behalf of the children. The input of the guardian will continue to be of importance, although she will not now be legally represented.
I agree. Like my lord and my lady, I start off with a strong instinct to uphold case management decisions by a very experienced judge, if the decision can be justified. Whether or not, I would have reached the same decision. However, I am persuaded by the reasons given by my lord that the decision of the judge on this occasion cannot be justified. I only add that for me, the critical feature is that if the judge's order were allowed to stand, there would be no one responsible solely for presenting the perceptions and submissions of the children in a case of very great significance for them. Although I am sure it is true, it is not a satisfactory response to say that the guardian will present their views while at the same time pursuing her application, which the children presently see as contrary to their interests. Finally, this is not a case in which there are any adverse welfare consequences to be anticipated from their having separate representation.
I agree with both judgments.
Thank you. Miss Kelly, could you kindly take the lead in drawing up a short order?
I will, of course, my lord.
We're very conscious of the fact that you and your solicitors have appeared pro bono, and indeed it's pro bono plus, in the sense you've had to pay to be here. And I'm not sure that anything can be done about that, but I express the court's appreciation of that situation.
In terms of the fee for issuing the appeal, my lord, we can make an application for that fee to be remitted, and I understand Miss Daly will be doing that.
Right. Is this a road that has been travelled before?
No.
All right. All right. Well, it's of course not a matter for the court to make an order about this, but I wish you well with that application.
Thank you very much, my lord.
Is there anything else? Will the order simply allow the appeal? We don't want large numbers of recitals, please. Just when it was who was here, the fact that the appeal is allowed. It doesn't have to have conditions, because those are in the note of judgment that you've had, and there'll be, I think, no order for cost.
Thank you, my lord.
Anything else?
Just bear with me on that. Just a point of clarification, Your Lordship, concerning the children's passports. I gather that they're in the judgment. You refer to the children's passport, orders about the children's passports. It's actually the parents' passports. and the protection orders were in response to the children only.
Sorry,
So-
I need to unpick that with you.
Yes.
Firstly, what did I say
I'll
to
just,
provoke
I'll
this,
just,
and then we can understand what the real situation is.
yes. It's about where you said these are matters of importance to the children, deprives them of their passports for 4 to 6 years. Actually, there's a previous determination which deprives them of their passports till they're 18.
Yes, so
And it's actually the
extension.
extension of concerning the orders concerning forced marriage protection orders.
Yes, and is
Rather
there an
than
application in relation
deprivation
to the
of
passports after the age of 18?
No, but it's in relation to the parents, that's my understanding. Yes, the father particularly.
I stand corrected. Thank you very much.
Thank you very much.
Thank you all very much for your assistance.
Thank you, my lord.
All right.